Welcome to the Laws of Style, featuring conversations on creativity, fashion, and the law from the leading edge of our economy and culture. Hosted by noted fashion lawyer Douglas Hand.
Hello, and welcome to the Laws of Style. I'm your host, Douglas Hand. And for this episode, I'm joined by fellow practitioner Ian Rosenberg. Ian is a First Amendment lawyer. We're going to talk about how freedom of expression, freedom of speech impacts the world of fashion. Ian, thank you for joining us today.
My pleasure. It's great to get to talk to you.
Well, so for our listeners who may not be familiar with your work, what's your story? I mean, what does a First Amendment lawyer do?
What does a First Amendment lawyer do? Well, a First Amendment lawyer can mean many things. For me, I have been a media lawyer essentially my whole career for the past 25 years. I started out clerking in the Eastern District, and so that was general litigation. But then I went to Cahill, Gordon, and Reindel, a white shoe firm on Wall Street, and had the great fortune of being mentored and working with Floyd Abrams, the dean of First Amendment law. And there I was a litigator who was working on media cases. And from there, I went to ABC, where for 22 years, essentially, I was ultimately VP and assistant chief counsel doing what's called, as you know, pre-broadcast review. So I was the lawyer looking at every piece of copy that would air on Nightline, for example. Anything the anchor said, anything the correspondent said, anything the script, any tweet, any headline, that was something that went through my review in advance, as well as other clients like WLS TV in Chicago, Live with Kelly and Mark from the Live with Regis and Kelly days. And from ABC, I'm now the general counsel of a documentary production company called Latchkey Films. And they're a great team. There's three partners, and Jackie Jesko is one of them. Her new documentary on Barbara Walters, Tell Me Everything, is phenomenal. It's recently on Hulu. It just had its premiere at Tribeca. And so a lot of my work is pre-broadcast review in the documentary context. It's more of a mix of different issues. It really can run the whole gamut of news gathering, intellectual property analysis, particularly fair use, trespass, privacy, Freedom of Information Act requests. It really can mean a lot of things. But for me, it has been primarily pre-broadcast review oriented for the last 20 plus years. And then also I teach media law at Brooklyn College. And in recent years, I've now finished my third book. And I'm happy to be on the show in large part because my second book, Free Speech Handbook, the graphic novel I collaborated on with Mike Cavallero, is coming out in paperback, a new updated paperback from Macmillan's new imprint, 23rd Street Press. And that will be coming out on on August 19th. So pretty soon. And
Very soon,
that's
yes.
an overview of what I've been doing with my law days.
No, that is fantastic. And I think, for those of our listeners that are considering law school, in law school, or just started their practice, I mean, I always think it's so interesting how many directions a strong legal background from a strong, I know you went to Cornell, great school, and starting at Cahill, I've always considered the first firm I started at as kind of a postgraduate education. You probably
Yes.
would agree with that. But your path, my path, many lawyers' paths taking you to far afield from what one another does, but with the same, kind of toolkit and skill set.
Yes, and I think it's maybe interesting for young lawyers to hear that I describe myself as a First Amendment or media lawyer, which is different than entertainment law. Now, not everyone uses the same terminology, but entertainment lawyers are usually people who do contracts for entertainment clients. that's my definition. Not everyone would necessarily parse things the same way, but I think sometimes it's helpful for people to know that there's a distinction sometimes between entertainment lawyers, which I don't necessarily classify myself as, or media or First Amendment lawyers, which I feel firmly in that world.
Yeah, no, that's a great point and good to point out. And I think, there's sort of another segment of what I would call media lawyers, or sort of media transactional lawyers,
That's right.
that do, yeah, licensing and M&A deals, all with media companies and with media content and intellectual property content from those companies. And that itself is sort of another branch of that overall tree. Uh,
Indeed.
but back to First Amendment. What's the most common misconception that people have about free speech rights in the U.S.?
Well, I love talking about this because a large part of why I wrote these books was to try and correct some of these misconceptions, and I have three. I'll maybe talk about two, but the first one is really fundamental to the text of the First Amendment. It says Congress shall make no law abridging the freedom of speech or of the press. Congress has now been interpreted, of course, through incorporation via the 14th Amendment to mean states, actors, as well as federal actors. But there needs to be government action to have a First Amendment legal claim. And so often, I think people will understandably get it confused. They'll say, my First Amendment rights are violated because my boss at a private company did this. And that might be violating the spirit of free speech law or free speech principles, but it does not actually implicate the First Amendment if there is not government action. And that's something that's sort of woven through the Fight for Free Speech and Free Speech Handbook, sort of makes that clear over time. Another misconception I think is important to point out is that people think that freedom of speech means freedom from consequences. And that is definitely not true. This is a more subtle misunderstanding. But for example, one of the cases I feature in Free Speech Handbook is the Pentagon Papers case, the famous case of the New York Times trying to publish the secret stolen documents about the Vietnam War. And ultimately, of course, the Supreme Court upheld the right of the New York Times to publish those papers. But I talk about in the book that it's much less well known that a majority of that same court also believed that both Daniel Ellsworth, who leaked the papers, and the publishers of the New York Times could have all gone to jail for publishing those papers. So they had a right to publish them, but they did not have a right to escape necessarily criminal prosecution for that publication. And so very often people will express their opinion, and then if anyone sort of pushes back on them, they'll say, oh, you can't do that. I have a free speech right to say that. And that's rarely true. We really may have a right to say something or to express something, but usually you also have to then face the music.
Yeah, yeah. Well, I'm curious. How do we stack up? We meaning USA, in terms of freedom of expression, freedom of speech on a global stage. I mean, obviously, I know there are regimes and countries where there's a lot that's verboten, but where do we? I think most people in the U.S. would say, well, we have the greatest rights. I mean, they are the broadest, they are the most permissive. Is that indeed true, or are there other countries where these freedoms are broader for the individual?
Well, I think that the short answer is that it is true that America has and I'm not an international comparative law expert, but I know about the First Amendment. And particularly Europe and some of Africa in terms of expression. And in general, we have the broadest First Amendment protections, even compared. I mean, no one else has the First Amendment, but we have the broadest free speech protections of any nation, even including sort of comparable democracies. England or other places, certainly compared to France. And so, in terms of your broadest array of free speech rights, that is the United States, hands down. Now, things that fall into the world of free speech rights that other people might prefer having less freedom, for example, hate speech, as I'm sure you know, is regulated throughout Europe and much of Africa. And there are pros and cons to that approach, but it's definitely a more restrictive approach. Whereas hate speech, one of the chapters in Free Speech Handbook, I talk about how the principles of hate speech being protected have been reaffirmed as recently as the last decade. So, so we do have the broadest free speech rights of any country, and I will give the little asterisk that the current court is really, with the ultra-conservative supermajority, is really changing so much about constitutional law. I am hesitant to be as sweeping in my description of our First Amendment rights as I might other be. And this conservative court is not as conservative on First Amendment issues, or is not as radical on First Amendment issues as they are in other places. Perhaps we will talk about that a little bit more later. But hands down, if you are looking for explicit protections for free expression from individuals versus the government, the United States by far has the greatest track record in protecting those rights.
Well, perhaps I should have started with this. Your jacket is fabulous.
Thank you.
And I want to know who makes it. And I'll give you an opportunity to answer that. But also, obviously self-expression, our apparel choices, our fashion choices are part of that. So what role does fashion play in, I'll start slow, just kind of your worldview. Cornell to Cahill to ABC, relatively conservative environments, maybe speak to your own personal experience in finding your own legs as a stylish man.
Well, thank you. And thank you for this jacket is an old favorite. It's Paul Smith, who's probably my go-to favorite designer of all time, particularly for the way he can work within a conservative tailoring, conservative traditional suits and jackets, but then with such amazing patterns and colors. And there's really no one else who does that, and it really helps as a lawyer who both wants to be a little bit less gray and drab, but also still knows that there are rules that our industry kind of still clings on to. I would say, in terms of my personal well, first, I went into First Amendment law in large part because I care so deeply about free expression on all platforms, certainly speech and writing, but also film and theater and fashion as well. In terms of my personal evolution of style in the law world, I've always been somebody who cared about clothes. I would say, when I was younger, I really liked the old man look. After a time, I realized it wasn't quite as ironic or winking as I've aged as I was when in my youth. So now I'm dressing, I think, younger. But also, the pen in which you're playing as a lawyer is very narrow. At Cahill, it used to be that you had to wear a suit. You could have your jacket off in your office, but you were always wearing a shirt and tie. And if you were wearing something, blue was considered a little radical when I started back in the late 90s, a blue shirt. And then at ABC, media lawyers in general dress, I would say, less like entertainment lawyers or fashion lawyers, certainly, and more like conservative corporate lawyers. And journalists, male journalists, don't generally dress nattily. So at ABC, most of the male journalists, have to dress very, very conservatively. I would say there are a few standouts. Martin Bashir, when he was at ABC, once stopped me on the street and said, "Could that be my lawyer?" Because I had a jazzy hat on as I was walking to work. There's a senior producer and correspondent, David Scott, who's now at Court TV, who's a friend of mine, who is always the most stylish man at working at ABC News. So I admired him. But there you were supposed to basically always have a sport jacket at the ready, for meetings with other news people who would often be dressed to go on camera. And then, and I used to always wear, so I went from always having ties to rarely wearing ties, to switching out of my dress shoes, or switching out of my sneakers into dress shoes at work, to just going with my Nike Air Force Ones all the time. So, I, and now that I'm general counsel for a small documentary production company, I can wear whatever I want. And one of the partners sometimes teases me about whether I'm going to go full Rosenberg, meaning totally crazy in my outfits. But thankfully now there's absolutely no dress code. This sport jacket is just for you.
Excellent. And all the viewers. But no, it is interesting, these pockets, these environments of lawyers and other professionals, and how they choose to present. And I do think, being a media lawyer, knowing exactly what that means, and sort of the newsroom, the newsroom kind of has this reputation of having all of the formal, it's a lot of tailored clothing, but there's not a lot of style. Like, it's just the obligatory, a lot of half knotted ties, and shirts unbuttoned, and badly stained gray sport coats, and all of that. So, I do think the lawyer signals a lot by what they wear. And
Well, and I was thinking about it for this podcast. I was thinking about, you just said signaling. It reminded me, when I was a very young lawyer, I was still litigator at Cahill. One of my friends got busted for jumping a turnstile at 3 a.m. She was coming back from a club, and forgot her wallet, and jumped the turnstile and got arrested and put in jail. And I got all these panic. This is back when there were voice machines. I got all these panic messages on my voicemail, or my answering machine, actually. So I head out to Brooklyn court to see if I can get into the jail that's in the back of the court. And it was a weekend, and I'm like, 25 at the time, and I put on a suit, and I walk in, and I've never done anything like this. And I walk in to try and see who I can talk to help my friend out. And a ADA comes up to me as I'm approaching them, and they go, "Hi, counselor, what can I do for you?" And it was just because of the suit.
yeah.
And I was like, "This is amazing. The suit has now enabled me to get a chance to see my friend." And so, yes, a suit still does signal law in, I think, all of American society, even today.
Well, so let's stay on that thread, if you will. But I do want to get into the book in particular. But inspirations for fashion, obviously you kind of learned at the feet of masters at Cahill.
Yeah.
Were some of your style avatars lawyers like yourself, or are there men or women in in the back of your mind as you think of your personal style that have inspired you?
Well, the only lawyers who inspired me by fashion, unfortunately, are fictional lawyers. So Gregory Peck in To Kill a Mockingbird, the white three-piece suit. I was in a play in college where I got to wear a similar three-piece suit, and it was one of the highlights of my acting career. And also Jimmy Smits in LA Law. That was an
Nice.
enormous influence on me. And those are the only legal sort of fashion idols that I would have. People that have inspired me outside of the law, I would start first with Virgil Abloh, the wit and intelligence, and sort of appreciation of the law too, melding with fashion, melding with art, as well as intellectual property issues with his quotation marks. Everything that Abloh did, particularly with Off-White, was an inspiration to me. Other inspirations would be, Paul Smith, we've talked about. Wes Anderson, I love a shrunken corduroy suit. I have one of my dad's vintage Calvin Klein bottle green corduroy suits that I was wearing before Wes Anderson, although he did inspire me.
That is fantastic, Mr. Fox.
Yes, indeed. One of my favorite Wes Anderson movies. And I would also, Jeremy O'Harris, a fellow Lower East Sider. He's such a amazing playwright, but also everything he wears is always so amazingly stylish. And then I would say my last fashion idol was also somebody that I sadly never met, but it was my grandfather. I'm wearing his necklace from Cartier right now. He was an accountant in the Bronx, but was so fashionable. He had all these beautiful Countess Mara ties that I now have. And they were all in the 50s, they were wide. And then in the 60s, he had them cut down, which, most accountants in the Bronx were not doing. But he knew that was now skinny ties were the fashion. So he did that. He also ended up becoming the accountant for Lacoste. He was the friends with the son of Rene Lacoste. And people used to tell my mom, why does your dad always wear lizards on his shirts on the weekends? This was early 60s before people knew much about Lacoste in the United States. And so I feel like I've inherited a lot of my style interest and eye from him.
Well, that's great. I mean, we're very much the same vintage, starting our practice in the late 90s and growing up in late 70s, early 80s.
Yeah.
When Lacoste was in full flower.
Yeah.
Obviously. Like that was a must-have item. My parents always made me actually buy those. They would get me the Le Tigre or the Fox, the sort of the cheaper version, the cheaper animal on the polo shirt. They didn't see the wisdom of the Lacoste shirt. But let's go to the job and the
Yeah.
for you, what's the most meaningful part of what you do?
Well, I really got into doing First Amendment law because I wanted to help journalists. I believe deeply in a free press. I do believe it is the bedrock of our democracy, as we are learning with increasingly worrisome situations that we're in right now. And so my favorite thing to do is to really support journalists in doing hard-hitting investigative journalism. I will often tell the producers and journalists that I'm working with, our goal when I would do annual training sessions, I would always say our goal isn't to never be sued. That would mean we're doing very bland and unimpactful work. My goal in working with journalists is to make sure that if we do receive a challenge, if there is a complaint, if there is a threat of a lawsuit, that we can feel 100% confident in saying, nope, we stand behind this report. We're open to hearing your concerns, but we feel very confident that we have addressed all those issues. So one of those just one example from my career at ABC would be working with the team on The Dropout. Rebecca Jarvis is the chief business correspondent at ABC News, and she brought me in early in her planning because they had come across this trove of the deposition audio. This was after the complaint had been filed against fraud complaints had been filed against Elizabeth Holmes for her blood testing company Theranos. But before before the trial had progressed, and when there seemed to be a lot of smoke, but no smoking gun. So we really had to thread a needle between bringing up a lot of serious accusations, but not drawing a conclusion that she was ultimately guilty. In fact, the smoking gun piece of evidence didn't come out until after the first 2 seasons of the podcast had been completed. So that's just one of the examples of when I felt like I was really adding to the team's production of fascinating and important journalism.
To being sued, right? I have a number of clients. They sue, they get sued. It is in the United States the cost of doing business. It's something that a business has to budget for. But what are your thoughts of the weaponization, if you will, of litigation? And I mean, our current president, well known for weaponizing litigation. The fact that for certain smaller players, even in a righteous cause, one that they feel the facts very much support, may choose not to litigate because the costs are so high and there is no guarantee of victory. And there is, in very rare instances, you might get legal fees reimbursement, but that is often not the case. And so the deep pocketed players, do budget accordingly and swing a very big stick, even when the facts aren't necessarily supportive of their causes. What are your thoughts there?
Well, it's an important question, and there's sort of a lot of parts to it, of course. We can take out for just a moment the inequalities that come from disparities of wealth, because that plagues the whole judicial system, and it's sort of too big a topic for this. I think there's a misconception, going back to your misconception question. I think there's also a misconception that because we have such protective standards for journalists, because of New York Times versus Sullivan, which again, I talk about extensively in the Fight for Free Speech and Free Speech Handbook, because we have an actual malice protection, people falsely think that, oh, journalists don't ever have to worry. Journalists aren't afraid of being sued because it's very difficult to win a libel lawsuit. And that's not true. I mean, there's whole teams of people, myself included, who are employed full time because of the potential devastating consequences of a successful lawsuit. And we're there to aid. I never, once I was at ABC, I was no longer in the litigation team. So I was always just in the up till air or any immediate complaints. So our goal was, very much concern about lawsuits. I just finished a new book that's a deep dive into the Dominion versus Fox litigation, which is called Terrible Stuff Damaging Everybody. The true story of lies and libel in Dominion versus Fox. That's a quote from Rupert Murdoch to Suzanne Scott, the CEO of Fox News, talking about Rudy Giuliani's press conference. And I think one of the surprising things about that litigation is that, in fact, the Dominion lawsuit is using libel as a vehicle for nailing down the truth. That libel actually can serve a really important truth function, and just because a hammer can be used as a weapon doesn't mean it can't also sort of nail down the truth. So Trump certainly uses libel as a weapon. And we can have a long discussion about that. He's both a libel bully and, in general, a libel loser. But I do think that the sort of truth-seeking elements of libel are sometimes under considered, and that's something I'm trying to explore in my new book, which will be coming out from NYU Press in the fall of 2026, so about a year from now.
Well, that's fantastic. But let's get to the Free Speech Handbook.
Yeah.
And I was very impressed with I have my navigation of my own background is nowhere near yours. So the Free Speech Handbook is a graphic novel. It outlines the fundamentals of the First Amendment. And I think, having looked at it in an engaging and, approachable way, sort
Thanks.
of not a case book, not necessarily geared towards law students or practitioners. What inspired you to write it?
Well, actually, it was my own kids who at the time were quite younger, who were in middle school, and it was sadly around the time of the shooting, the mass killing at Marjorie Stoneman Douglas High School, and they were interested in participating in the National School Walkout, which was a protest movement among students to walk out of their classrooms and seek sort of a national awareness about the lack of action on reasonable gun safety laws. And my kids were both at a public school in the East Village, a very progressive public school, but they weren't sure what would happen to them. And I realized in talking to them that wisdom, as brilliant as they are, they were still middle school kids. And I realized talking to them that wisdom can be condensed without being dumbed down. That's a paraphrase of a Timothy Snyder line I love, the Yale historian and an author of On Tyranny, which is still, I think, the best book on the crisis we're facing in democracy in this country right now. But so I was really inspired to start explaining free speech law based on contemporary controversies. So as you were starting to say, each chapter in Free Speech Handbook and the book it's based on, The Fight for Free Speech, begins with a contemporary controversy, like the National School Walkout, or Colin Kaepernick taking a knee, or the Women's March on Washington, social media trolls, and then it answers those questions by doing a storytelling look at the people who fought in a particular case that wound its way up to the Supreme Court and ultimately decided our rights in that area. And so I thought that the combination of being able to write a book for non-lawyers or people who are non-experts in the law or in First Amendment law, based on contemporary questions, would be hopefully an engaging way to draw people into what can be, in other contexts, off-putting and complicated material.
Yeah, yeah. Well, so it brings to mind the chapter Take a Knee, the Pledge of Allegiance,
Yeah.
which opens with the story of Colin Kaepernick and how his decision to remain seated during the national anthem began to draw attention, particularly when he was doing so, in uniform. And I think at the time he was a San Francisco 49er. For our listeners who haven't yet had a chance to read the book,
Yeah.
could you speak about why the fact that he was in uniform maybe made that moment more impactful and perhaps controversial?
Yeah, I mean, I think you're really honing in one of the things that I love about the graphic novel, with this amazing art by an Eisner-nominated and very successful graphic novelist named Mike Cavallaro, who I didn't know, but we now are good friends. Mike has, on chapter 2, on Take a Knee, Mike has two panels that I think stick out more visually than you would if you're just reading it. And the first 2 days, first two times in August of 2016 that Kaepernick sat down during the national anthem, sat on the bench because he started sitting. Sat on the bench. He wasn't in uniform. And it was in part because he had a shoulder injury and he wasn't going to play those days. But it wasn't until the third time that he stayed on the bench. This time, injury was improved in uniform, that he started getting asked questions, and he gave his first famous press conference, was saying that he was refusing to stand up, paraphrasing, that he was refusing to stand up for the anthem of a country that discriminated against black people and people of color, particularly in the police brutality context. And one could say, oh, maybe it's because he wasn't injured anymore, or maybe it's third time's the charm. That's the reason that people paid attention. But I think you are hitting on actually the key point, which is that people paid attention because there was a powerful symbolism connecting a NFL uniform with the refusal to stand for the Pledge of Allegiance. Uniforms can mean so many things, but I think the combination of professional football, the combination of being ready to go. What a uniform, just like a suit, says I'm ready to talk in court. A football uniform says I'm ready to play, and it was really conveying so much. And we can talk later about the sort of expression, the how much fashion expression is protected by the First Amendment. But even separate from the First Amendment, I just think it led to the iconic nature of the initial protest, was the image of him in uniform staying seated.
Yeah, yeah. Well, in particular, at the beginning of the game, I mean, you are ready to go. The uniform is spotless, and
That's
we all
right.
know by the end of a game, it usually is not, particularly for a starting quarterback. Um, so, I mean, it seems. I think we both know there's real significance in what people wear in terms of statements that they're making. Clothing being a very powerful vehicle for nonverbal communication. Um, so, from a First Amendment standpoint, would you consider that a protected form of expression?
Absolutely. So we can again talk about them at more length, but there are two key cases from the Supreme Court, both of which are in my book, that talk about protected expression based on what people are wearing. And one, I'll just say briefly, one is Tinker versus Des Moines, in which a young high school, actually middle school student, Mary Beth Tinker, wore a black armband that she had sewed together from her mom's sewing basket to protest the war in Vietnam and to honor the dead on both sides, which is a very radical notion in that time in Iowa, that you would also care about Vietnamese deaths. And that case led to a stunning victory and the beginning of the recognition of student speech rights. And then there's another case called Cohen versus California, which is, I assume I can curse on here. It's the Fuck the Draft t-shirt case. A man wore that into a courtroom and led to greater expressive protections about the emotive content of words, not just of what might be written down. So it is there is strong precedent that what you wear is part of your First Amendment rights. There has been some recent backpedaling that's a little concerning. The court has turned down some cases that seem to override circuit protections, or a circuit case that seems to override sort of the Tinker sensibility in terms of students wearing conservative T-shirts, T-shirts with a conservative, more Republican or far right message. So that's a little troubling, but the bottom line is that what you wear is absolutely can be part of your First Amendment expressive rights that are protected.
So, are there other examples of people's apparel choices, getting them into legal trouble? Maybe a Confederate flag, maybe a swastika. I mean, there's a lot of iconography that is triggering, and in certain situations, one might argue is over the line in
Yeah.
terms of and where is that line for our listeners who are like, oh, there's a line.
Well, it's an excellent question, and in fact, there are cases. There is a series of cases about somebody wearing a Confederate flag T-shirt to school in a more more I'm oversimplifying, but in a more liberal school where it was not welcomed, and I think that one of the great things about the First Amendment is that it is often championed nowadays. It is often championed by people on sort of both sides or sort of all sides of the political spectrum. So, and I think that it's a helpful. One of the things I often ask my students to do is, I'm teaching at Brooklyn College, so there's a certain demographic, and there's a generally to oversimplify a more liberal outlook, but not always, but generally. And one of the things I often ask them to do is to flip the politics of what we're discussing and see if people still feel the same about the protections. So if you feel great about Mary Beth Tinker having the right to wear an armband to protest the Vietnam War, which now feels like, well, everyone, half the country was protesting the war, although at that point it was a much more popular war when she began her protest. But do you feel the same if it's a swastika or if it's, less horrific, but, as you bring up a Confederate flag or some other one of these T-shirt cases that the court just turned down was a T-shirt that said there are only two genders. To take a conservative stance on that, and to me, the actual test in Tinker is a foreseeable likelihood of substantial disruption, which doesn't roll off the tongue, but basically means you can't just fear some disturbance. You have to have some reason to believe some concrete reason to believe that there will be a substantial disruption. Not that somebody might tease the person for a minute before the bell rings, but that there's something bad is going to happen. And I think that's a good test. And what's what's important about that test is that it is viewpoint neutral, and that it takes away from administrators the power to control what their students wear simply because the administrators disagree with the politics of it. And I think that's where the line should remain.
Hmm. Interesting. Interesting. So this is related, but maybe just more general. I mean, the intersection of fashion and politics and making political statements through dress, whether that's a woman dressing in traditionally male clothing to announce her sexual preference, or outright iconography, like a Confederate flag or something else. Do you think that's impactful? Do you think it's in a way less impactful than speech itself, which requires a little bit more proactivity on behalf of the person trying to communicate that political stance?
I do think it's impactful. And, yes, of course, there's always the concern about tokenism and, oh, this person just put on a t-shirt for 1 minute and they're not true to the cause, or they're just doing it for the likes or whatever. But I believe in the marketplace of ideas, flawed metaphor that may be, the first chapter of my book, sort of the foundational metaphor of all free speech law, which is that the government shouldn't interfere with what people are bringing into the marketplace. And I live on the Lower East Side, so I like to think of it as like an old-fashioned marketplace around Orchard Street where people are yelling about their different pickles, and somebody's telling you those pickles are rancid, and somebody else is telling you don't buy that herring. And they may be lying and they may be not. I believe that people, I think sort of any discourse about politics can be impactful. And in many ways, the right celebrity or the right political figure wearing a t-shirt on Instagram can have so much more impact and reach than a hard-hitting editorial in the New York Review of Books, that might be preaching to the choir, that might not get half the views. So I'm all for the linking of politics and fashion. I see it as part of expression. That's why I don't love the idea of dress codes, either in schools or necessarily in law firms. With Kaepernick being taken up by Nike, I think there's a lot of interesting stuff in there. I don't know if you want to talk about that more, but that sort of feels like where you're leading.
No, absolutely. I mean, that is on a broader scale, right? That's a whole organization, a business taking a political stance through arguably fashion choices, and it can communicate a lot quickly, which I think is the power of advertising, right? I mean, the power of marketing, that you get an image and you get an entire story behind that image, whether that's because of what's happened and transpired, or just the visual itself just evokes that, and that can be very powerful. And to your point, part of a dialogue, which is, I think, what both sides of the aisle in most cases want.
Absolutely. And I mean, I think just, going further with the Kaepernick example, it was interesting to me because you and I had been talking about this before, and I looked back at sort of the first the hardcover book I had on the fight for free speech, and then the paperback, and I had thought I had made this change, but I did. Originally, I talked about Kaepernick's partnership with Nike, and saying that, well, it showed that protest could be profitable. And I meant that for both Kaepernick, the large amount he was paid, and Nike, who's, it seems like, there's a lot of ways to look at it, but it seems like their business did extra well after their partnership. But I on reflection, after a year or two when the paperback came out, I decided I felt that was like a little snide, or could come off as a little dismissive. I hope not snide, but a little dismissive, which was not my intent. And so I talked about it to show that how a business can really give a platform to protest. And I think it's so much more interesting to look at how Kaepernick was using Nike rather than what Nike and their, many problems with that could be attributed to their company are gaining from him. So, in general, I'm supportive of the mixture of fashion and law, and care less about the potential caveats or carping that people can legitimately bring up when that's introduced into the public discussion.
Yeah. Well, I think we touched on this, but I'll allow you to perhaps deep dive a little bit more. When people use themselves mainly through a t-shirt, right? Or a hoodie as billboards. You have a chapter flipping off the president and fuck the draft.
Yeah.
And you explore the Cohen v. California case, which centers on the use of an expletive in clothing. So how protected are messages on clothing under the First Amendment?
Well, let's just start with how protected cursing is, and the clothing element was integral to the facts of the case. But I think it goes beyond this. Is where the court ultimately went in Cohen versus California. So this is in the '60s. He's wearing this T-shirt that says. He's wearing a jacket that says "fuck the draft" on the back. Actually, interesting. In much later interviews, he said he didn't even write it. It was some girl he met had drawn it on his jacket when he didn't realize. So he's wearing it in the courtroom. A bailiff or some kind of law enforcement official was angry about it, said something to the judge. The judge was like, I don't care. Nobody's noticing. He was there just to be a witness in a traffic case, Paul Cohen. But the law enforcement guy was angry anyway, and arrested him outside of the court room in the courthouse for essentially a disturbing of the peace charge, even though no one objected, and was supposed to be sentenced to 30 days in jail, which felt like very much a punishment based on the message rather than the actual disturbance. And the court, in one of their most poetic expressions of our First Amendment rights, said that one man's vulgarity is another man's lyric, which is a line I love. And more importantly, it was the court recognizing that you not only have a right to say, I protest the war in Vietnam, or I'm opposed to selective service and the draft. You have a right to express the emotive content of what you're feeling. Fuck the draft is very different than I oppose the war. And so by recognizing the power of emotion to count in your message, whether it be on your jacket or whether it be in some other form, the court was really protecting an important speech right. Now, you do not have a right to curse on broadcast television or radio. And that's another case I talk about in the book that starts with George Carlin's Seven Dirty Words monologue. So in general, your right to express even what some might consider outrageous messages through clothing or otherwise are protected, and I believe should remain protected by the Supreme Court.
Well, so congratulations, the book going to paperback. I mean, as an author myself, I know what an achievement that is. But if there's a chapter you could add at this point, what would it be?
I get asked that question a lot when I do book talks, and in recent days, I have one. It used to sort of go back and forth, but I have one clear answer, unfortunately, and that's because of since the book's original writing, the wave of censorship we've had facing classrooms and school libraries and public libraries has really become an epidemic. The American Library Association has charted about explicit efforts at censorship, and not everyone gets recognized by them. And the numbers are more than double what it had been sort of in the decade, just on a yearly basis, almost more than double than what they've been in previous decades. since really the 80s perhaps. And so the case I would bring, so that's the current, every chapter in the book begins with a current controversy. So the current controversy would be the rise of censorship in our schools and libraries. And then the key Supreme Court case on that is called Island Trees versus Pico. It's from 1982. It was an attempt from a New York upstate school board to restrict books from a school library, including Bernard Malamud, James Baldwin, I believe Kurt Vonnegut, purely because there's a lot of facts on this, but purely because the school board didn't like them. And these were all acclaimed books. Everyone sort of acknowledged that they were acclaimed and important books. And in a divided opinion, in a complicated, and one of the reasons I also didn't include it initially in the book is I'm trying very hard to make the law clear. And so I was particularly picking the cases that have the clearest answers to contemporary questions, not ones that need a sort of a lot of legal commentary. And there's a fair amount of legal commentary that you need on Pico, but the shortest version is that a divided court held that school libraries or administrators cannot restrict books included in school libraries merely because they disagree with the message of those books, merely because they disagree with the viewpoint of those books. And I think that's a really important case for us, for people to know about. I am not convinced that our current court would support the Pico decision, particularly because it was a conflicted opinion. And so I worry about that. There are really interesting efforts by publishers currently to try and fight sort of from a more corporate perspective against these censorship efforts. Previously, it had just been authors or individuals who have been fighting these challenges. Now, the major publishers are getting into that fight, and I salute them for doing that. But Pico and the censorship in our classrooms is a real challenge that we all need to address. And I don't know whether to take it as a badge of honor or not, but Free Speech Handbook was essentially censored in Lynchburg, Virginia, from schools. So it's a longer story,
Badge
but
of honor,
but
I
I've
would
now
say.
experienced what I'm trying to fight against. It felt like a real irony to have my book on free speech censored, but that is the world we're living in.
Well, kudos to you for that. Well, this is maybe, there isn't necessarily case law here or but the evolution of the First Amendment. We have, I feel like it's always a polarized political environment, but being in my mid 50s, I mean, it feels like more so than ever, at least in my lifetime. The rise of social media, you and I came to sort of personhood before most of our lives were put on a platform for people to comment on and freely sort of dissect if we put things up there. And then also AI and sort of how that may impact the First Amendment. I know that's somewhat of a triggering sort of omnibus throw in, but any of those elements that you see might cause the interpretation of the First Amendment to evolve in some way?
Well, I firmly believe that the future of free speech is online, that the future of the court's free speech and First Amendment doctrine is going to be all about social media and the internet in general. The court has been very reluctant to address this. Chapter 10 of my book, the last chapter of Free Speech Handbook, talks about social media problems and then talks about, up until recently, really the one key case that the court in the 2000s that the court has addressed social media in particular. It's a case called Packingham. It was Justice Kennedy's one of his last major decisions before he stepped down. And in it, there was a state law that restricted convicted sex offenders from having essentially any access to the internet or social media, not just sites that might be focused on children, but any access whatsoever. And the court held that the vast democratic forums of the internet, to use Kennedy's phrase, were so important and so integral. They were like a megaphone on steroids, another paraphrase that he was using, or the town crier on steroids, and that therefore even laws targeting sex offenders had to be struck down because the First Amendment rights of even these disfavored individuals. In order for people to express their First Amendment rights, the internet and social media were so central to our lives today that they could not be restricted. In general, the court's approach, I believe, has been the right one in that it is treating the First Amendment online the way they treat other platforms. I mean, you were talking about the evolution of the First Amendment, and if you're looking at it from a platform perspective, every time there's a new major platform. So we start with radio, and then there's efforts to sort of restrict radio. Certainly, well, there was efforts to restrict books. Then we sort of get past most, Ulysses and Howl, and we get past that. And then there's efforts to restrict movies and The Miracle, and then we get to violent video games, and the court says no, we're still protecting people's expressive rights, and so now with the internet, up until this term, the court has either ignored the issue or they have basically been platform agnostic and saying that social media is important, and that all the big First Amendment protections that we have for other medium apply to the First Amendment. Just this month in Paxton, Free Speech Coalition versus Paxton, a very distressing case from 6-3 case, with the conservative majority deciding that a Texas law that requires age gating for adult potentially sexual content is withstands doesn't need to withstand strict scrutiny. That's a legal terminology, but basically the court upholds a law that requires age gating for content that is legally protected for adults. And up until now, there have been decades of Supreme Court precedents that have said that, we do not restrict adult access to materials because, in theory, children may be injured. I always think of the woman on The Simpsons, I forget the character's name, who clutches her pearls and says, "But what about the children?" And that idea has been rejected by the court. Until now, in Paxton, Justice Kagan points out how this is overturning years of precedent, and the ACLU has criticized this. So it seems like this court might now be rethinking internet protections, social media protections on a platform basis, or more cynically looking at it, any type of conservative-based morality restrictions are going to have a much more receptive eye with this current court. Maybe it's not about the platform. Maybe it's just about efforts on restricting morality or what people perceive to be the moral issues regarding sexual content. So I think we are in a very uncharted territory right now. We do have Justice Roberts, who considers himself, Chief Justice Roberts, who considers himself the foremost fighter, defender of First Amendment rights. I do not think he's as strong as he thinks he is, but he does care about these, and so we're in a situation where Roberts and Barrett and Kavanaugh are the swing votes we have on First Amendment cases. Which is, just sort of a distressing place to be if you care about free speech rights. Yeah. So that's a long answer to your question, but the future of free speech rights are online, and it is very unsettled. One of the reasons why I hope people read Free Speech Handbook is if things are going to be unsettled and dismantled, I want people to know about what is being potentially taken away from them. And the only way you can learn that is from hearing about these cases from the past.
Yeah. Uncharted indeed. Well, the book is the Free Speech Handbook. The author is Ian Rosenberg. Ian, thank you so much for joining us today. And listeners, thank you for tuning in. We'll see you next time.
Thank you. It's a pleasure.
Bye now.
You've been listening to The Laws of Style with Douglas Hand. For more information, go to our website at www.hballp.com. And you can also follow us on Instagram and Twitter at Hand of the Law. Thank you for tuning in, and stay stylish.